Hi, okay, well, good afternoon, everybody, and thank you very much indeed for joining us for this, which is the first session being run by the Doughty Street Immigration Detention Group in 2022. We have about 32 people, I think it is, on the seminar so far. I'm sure a few more people are going to be joining over the next 5 or 10 minutes, but I thought I'd kick off with the introductions and hopefully we'll have a full house by the time the talks begin. Can I just start, please, with a couple of housekeeping points? The first is we hope to have some time at the end to take questions. It would be helpful to us if you could put the questions in the Q&A box in Zoom rather than in the chat. The second point is that towards the end of the seminar, you should see on your screen a poll for feedback. We'd be very grateful if you could complete that before logging off at the end. And the third point is just to let you know the slides will be circulated together with a link to the video of this session at some point over the next few days. So don't feel impelled to write down everything that we're saying as we're moving through this. I wanted to kick off by saying a little bit about the detention group at Doughty Street Chambers. It's really a sort of informal internal grouping that is aiming to pull together the expertise of the immigration team, the public law team, and the team that works on actions against the police and state, in recognition of the fact that a lot of immigration detention claims, whether in the private law sphere or the public law sphere, really bring in skills and knowledge from all those areas. And we thought pooling the expertise of the practitioners in those three areas to focus in particular on issues arising in immigration detention case could add value to what we're offering in this area. And certainly as somebody with a primarily immigration background, I've learned a great deal from colleagues with a more solid sort of civil claims background in terms of their grasp of civil claims procedures. So it's partly an exercise in internal knowledge sharing, but we also put on external events like this seminar. We have another seminar coming up in June that's a more advanced sort of updating session, and we're hoping to put on a full day session later in the year in October, dealing with detention related issues arising out of the new Act and other matters. So the plan is to have a steady stream of seminars and other events focusing specifically on issues related to immigration detention. Today's session is focusing on the Hardial Singh principles. It's not the most glamorous topic in this area. The legal principles are well trodden and may be familiar to some of the participants on the call, but the reality is the Hardial Singh principles are at the heart of the vast majority of immigration detention challenges. They either form the sole basis of the challenge or they are grounds of challenge alongside other public law grounds. And we need to be familiar both with the sort of basic propositions that make up the Hardial Singh principles, but also with the nuances of how we approach the legal issues that they give rise to and how we approach the practicalities of actually considering a claim, investigating a claim and getting a claim on foot. They're obviously equally relevant to civil actions for damages brought after the fact and also to public law claims seeking release from detention. The working assumption from what we're talking about today is that we're talking about judicial review claims, but most of what we're talking about is also relevant to civil claims. I'm joined by my colleagues Donnchadh Greene and Agata Patyna. Donnchadh's going to be talking about the sort of core principles. Agata is going to be delving a bit more into issues around the elusive concept of reasonableness in the concept of Hardial Singh. Donnchadh's going to be speaking first. If I can just briefly introduce him. Donnchadh has a practice that encompasses immigration detention in both its the civil aspect and in public law challenges. He has long experience acting for immigration detainees in bail proceedings before the First Field Tribunal, and he's trained trained solicitors on that. His immigration detention work is in the context of a broad-ranging practice in public law and discrimination work that takes in the full range of chambers work in those areas. And with that, I'll pass over to Donnchadh for the first talk. Thank you very much indeed.
Thanks so much, Graham. Sorry, I was just working on unison. I will take a very brief overview of kind of the very back to basics Hardial Singh principles, and we'll just get started with the key principles on that. And so most of this all originates from the concept that the freedom from executive detention is a very core right under the common law, and it's considered very seriously by the courts. This is a quote from Lord Brown, who's citing Lord Bingham's extrajudicial statement on in the case of Limbo, which is a well-known case in this area. So kind of giving a brief overview of the circumstances about when detention will be unlawful. So first of all, obviously, where there's no power of detention, so often the power to detain comes from statute, and the specific powers in which that arises are outside of the scope of this training. But there's plenty of resources around that we can also discuss later on. Second, the detention is in breach of the Hardial Singh principles. So even where there is a lawful or a statutory authority to detain, they still have these core principles that keep a guard on the executive power to detain. And those are in line with the requirement to act reasonably and also to act in accordance with the statutory purpose for which the detaining power is given. Third, that it's a decision to detain is tainted by a material public law error. And finally, about breaches of Articles 5 or 8 of the European Convention on Human Rights, Article 5 being the key one about the right to liberty. And so I'm not going to specifically use the quote of Hardial Singh from where we get Hardial Singh principles, but this is the distillation of those principles by Lord Justice Dyson, as he then was, in the case of I. And he elucidated 4 key principles which set forward when it will be legal or lawful to detain, or when the legality will expire. So first of all, the first principle is that the Secretary of State must intend to deport the person and can only use the power to detain for that purpose. Second, the deportee may only be detained for a period that is reasonable in all the circumstances. Third, if before the expiry of the reasonable period it becomes apparent that the Secretary of State will not be able to effect deportation within that reasonable period, he should not seek to exercise the power of detention. And finally, the Secretary of State should act with reasonable diligence and expedition. Now, Agata is going to take the second and third of those and go into them in more detail, but and I'll take the first and fourth very briefly. Before we do, it's a good guide to look at the court's approach to these. And so the court puts itself in the shoes of the primary decision maker. It's not a reviewing jurisdiction in that way. However, as Lord Justice Toulson said in one of many A cases, there may be incidental questions of fact which the court may recognise that its Home Secretary is better placed to decide than itself, and the court will no doubt take such account of the Home Secretary's view as seems proper. And in doing that, it's looking at what was available to the Secretary of State at the time. There's no hindsight or what they should have known or shouldn't have known, save for specific questions of fact, which are taken to be precedent questions of fact, such as citizenship. There's no scope for hindsight in that way. Whether or not there's a burden of proof is slightly contextualized. It is in the Secretary of State to establish lawful authority, but often, as the quotes highlight, you will be looking at whether or not it is lawful, and you'll be kind of arguing about whether it's lawful. So burden of proof kind of fits outside that. But as made clear in ZA, it is for the Secretary of State to demonstrate by evidence that the principles have been adhered to. And so when you raise that case, it's for the Secretary of State to deal with. However, it can be more or less useful depending on the case. So I'm just going to traverse the first Hardial Singh principle. As it says, must intend to deport the person and can only detain for that purpose. So in a case of AA, which was an individual who was being detained purportedly to prevent their suicide, it was held that that was an improper purpose because they couldn't be detained for his own protection. In a slightly different context, in the false imprisonment context, there's a recent case of Archer, considering the bail provisions where you can be detained for your own protection, but that's different from this circumstance because there is no statutory power to do that in the context of immigration detention. So just to be aware that where the case law is moving in the Article 5 context. And this is kind of jumping ahead. So the fourth Hardial Singh principle is about reasonable diligence and expedition. It ties in to what is reasonable, because most likely if you've not been acting diligently or expeditiously, it'll be less reasonable to continue to detain in those circumstances, but it is still a freestanding ground upon which detention will be unlawful if it's sufficiently serious. So, and that's established in Krasniki, and the example there of JS Sudan is administrative inactivity of 12 months, which rendered the detention unlawful in that case. And those are my slides. I'm going to hand over to Agata, who's going to take it from there.
Thank you very much, Donnchadh. If I can just briefly introduce Agata. Agata, I'm sure, is well known to many, if not all of you, as a very highly regarded specialist across the various areas of immigration law that we practice in chambers, combining that with an expertise in children's rights and public law more broadly. She's very experienced in dealing with immigration detention, and I'm sure she's going to be able to cast some light on how precisely one grapples with this, on the face of it, very simple, but in practice, really quite complex concept of reasonableness in Hardial Singh claims. Agata, thank you.
Thanks very much. Before I start, I just wanted to remind you, or tell you if you haven't attended one of our webinars, that at the bottom of your screens you have a little sign saying Q&A. And if you have any questions, and we'll try to leave a lot of time at the end for questions, this is where we would like to put them, and we'll monitor this little box throughout the seminar. So my session deals with the simple but complicated question of what is reasonable, with relevance to our Hardial Singh principles 2 and 3. I just wanted to make 2 points by way of an introduction. The first is that the second and the third Hardial Singh principle are conceptually different, as was emphasized by Lord Dyson in I. And so there may be circumstances where a reasonable period has not yet expired, but it becomes clear to the Secretary of State that the person will not be able to be removed or detained within a reasonable period. And then the third principle kicks in. So you may have clients who have not been detained for very long, but it's very obvious from their circumstances, for example, whether they are from or the barriers to their removal, that detention, if they're not released, will continue for a period which is not reasonable. And in those cases, detention would be unlawful under the third principle. The second general point I wanted to make is that the assessment of what is reasonable in each case is fact specific. So there isn't a table you can go to which will tell you that after a certain number of days, detention for a foreign national becomes unlawful. There are no tariff periods, and as was emphasized in the case of Fardos, it is inappropriate to cite past cases in support of what would be lawful or unlawful. And in that case, the Court of Appeal said that there is no period of time which is considered long or short, or no particular fixed period where a person should be detained. And efforts at quoting previous decisions were seen as a waste of the court's time and resources. And in Graham's section in particular, he will deal with how practically you can argue that in your particular case, the period of detention is unreasonable. The third general point is about the prospect of removal. So the Secretary of State must show that there is a sufficient prospect of removing someone in order to warrant continued detention. And that is a question of balance in each case. One case which the Secretary of State really loves to rely on is MM, which I have cited in this slide. And in that case, the Court of Appeal said that the Secretary of State does not need to demonstrate a definite time frame by which he will remove someone. So a removal could be realistic without being able to predict a date or even a period, within which it can reasonably be expected to occur. But of course, you may have in the papers the Secretary of State estimating what the removal period might be, and that can help you argue whether or not she herself thinks that the period would be reasonable. So what are the factors which in each case the court may look at when assessing the reasonableness of the period? I would say that the factors which were identified in the decision in I and approved in number come under three headings. So first, you've got the factors which are, let's call them general factors, not entirely dependent on the Secretary of State or the individual. So for example, where the person is from and what the difficulties in obtaining an emergency travel document might be for them. Or perhaps relevant now, but in the circumstances of the pandemic, what the travel restrictions were in terms of returning to that country. Then you have the factors which are specific to the detainee. And then you've got factors which relate to what the Secretary of State has been or is doing. So the factors include perhaps the most obviously the length of the person's detention, then the nature of obstacles to their removal, and the degree of certainty or uncertainty surrounding those obstacles. They can come in a number of forms. So, for example, pending litigations or challenges, and again, there's a range of those. There could be a pending asylum claim or a fresh claim, an appeal, a judicial review, a pending referral to the national referral mechanism for a potential victim of trafficking. Other litigation, for example, criminal proceedings, pending prosecutions. The second category is obtaining emergency travel documents. So if you're dealing with a client who doesn't have a document on which they can return to the country of origin, you will need to be aware of the procedures which are necessary to obtain that document. And I know that Graham will touch upon that a bit more. And then thirdly, there is the extent to which the detainee is cooperating with their return or redocumentation process. The next factor, and Don has talked about it a bit, is the diligence, speed and effectiveness on behalf of the Secretary of State to attempt to surmount those obstacles. And as you heard, the lack of such diligence can be in and of itself a ground of unlawful detention under the fourth principle, but it also feeds into the consideration of what is reasonable. So perhaps the delay or lack of diligence is not serious enough to be a basis for a breach of the fourth principle, but would still be relevant to whether the person is unlawfully detained under the second and third principle. The other factors, as I said, are those more specific to the detainee. So the condition in which that person is kept is one such area, and of particular relevance recently has been the issue of whether the person is detained within an immigration detention context, as an immigration removal center, or the prison estate, especially because the circumstances of detention within the prison estate during the COVID pandemic have been particularly severe. There is then the impact on the detainee and people close to that detainee, including their family, and in particular, minor children. And then the two considerations which appear time and time again and have been, again, time and time again, characterized as paramount considerations are the risk of the person absconding and the risk of them reoffending. However, it has been emphasized that even if a person is at high risk of absconding or reoffending, it is not a trump card and it cannot justify indefinite detention. And the acid test always has to be whether there is a realistic prospect of effecting a return. On the risk of offending, I should say that in the case of A, it was highlighted that this risk takes into account two broad factors. So one is the likelihood of offending or reoffending, and the other is the potential gravity of the consequences of offending. So you may find, for example, that the court would decide that a prolific offender who only commits petty crimes, who is at high risk of offending, should be detained for a relatively shorter period, all things being equal, than someone who's at a medium risk of reoffending, but that person's offending was serious, for example, included drugs or sexual offences. The important thing to remember is that the list in I is not exhaustive, and there will be factors specific to your case which may not be easily covered by that list, or perhaps factors which necessitate a more nuanced approach to that list. And as I will describe in the next slide, these factors are in any event recognized in the Secretary of State's own policy. One of the factors which has been repeatedly recognized is whether the detainee is mentally ill. And it is accepted that those who are suffering from mental illness are likely to be more severely affected by the experience of detention. And again, all things being equal, a person with mental health issues should be detained for a shorter time than someone who doesn't have those issues. We did say, I think in our blurb, advertising this seminar, that we'll talk briefly about Home Office policy. And as Don explained, a breach of relevant policy or guidance can be a separate ground of unlawful detention, namely a material public law error bearing upon the lawfulness of detention. But those policies are also relevant to assessing what the Secretary of State sees as a reasonable period. I highlighted two policies. One of them is the adults at risk in immigration detention, and then a sub-policy specifically on detention of potential or confirmed victims of modern slavery. And both of those policies recognize that adults at risk, so those, for example, who are victims of torture or have mental health issues, are likely to suffer more seriously from the experience of detention, and the presumption in favor of release is greater in the cases of those individuals. The adults at risk policy, as probably most of you know, identifies three levels of risk, so to speak. It's really level 2 and level 3 where there is medical evidence of the person's vulnerability, which is relevant. And it provides criteria as to when these individuals can be detained, with reference to also the likelihood of removal. In terms of victims of trafficking, there are useful sections in the policy which recognize that if someone receives a positive reasonable grounds decision and so is recognized as a potential victim of trafficking, they cannot be removed until a conclusive grounds decision, and that is likely to take could take a considerable time. And those of us who deal with trafficking cases will be well familiar with the repeated comments of the courts on lengthy delays in the NRM process, most recently made by the Court of Appeal in the case of EOG and KTT. And it's useful when dealing with cases involving detention of potential victims of trafficking to quote those comments. One of the other factors that is described in I is and Lumba is the relevance of legal proceedings delaying removal. And in Lumba, the Secretary of State was effectively trying to argue that if a person makes an asylum claim or brings proceedings which delay their removal, the period to resolve that legal challenge should generally be left out of the consideration of whether a period of their detention is reasonable. And her reasoning was was twofold. One, she was trying to say, well, that the issue is then left out of the Secretary of State's control because the person can frustrate the removal process by bringing hopeless challenges. And then the other concern she raised was that a person may simply bring the challenge, be released, and then abscond, which would defeat the purpose for why they were detained. And the court in Lumba rejected that exclusionary rule, but said that the courts can assess whether a challenge is hopeless or abusive. And if that is the case, the time spent pursuing that challenge is likely to count very little into the assessment of what is reasonable. And when looking at whether a challenge is hopeless, the court reminded itself of the statutory provisions available to the Secretary of State for certification of claims which are unfounded or claims which have been made before under the 2002 Act. It also noted that the court may have available to it previous determination assessing the person to lack credibility. But for example, in cases where orders have been made for the Secretary of State to reconsider the claim, or the higher courts have granted permission to appeal, those cases cannot prima facie be considered unfounded or hopeless. And I should say also in the context of fresh claims, if the Secretary of State has accepted that the claim has a reasonable prospect of success, then despite a previous refusal of a claim, then it is difficult for her to argue that that challenge is hopeless. So this really is a lengthy quote, which I'm not going to read out. And as Graham said, you'll get the slides, but paragraph 1-1 of Lumba summarized in much better than I have explained it, the relevant principles. The other aspect which is relevant to what is reasonable is what the detainee has been doing, or more often not doing, in order to progress their removal or deportation. And it is recognized that there is a difference, sometimes missed by the Secretary of State, between the person simply saying that they don't want to refuse voluntarily, but more or less cooperating with the removals process. So for example, a person simply saying, I will not sign the assisted voluntary return form. There's a difference between those cases where the court in Lumba said that the refusal of voluntary return is unlikely to have any relevance, and any relevance would in any event be limited. On the other hand, there are cases of non-cooperation and obstruction, and in those cases, behavior which is obstructive or non-cooperative is likely to significantly lengthen the reasonable period of detention. But note again that there is a wide range of conduct from non-cooperation with an emergency travel document process to, for example, cases of elaborate deception about the person's identity or nationality, which significantly delays a person's removal. And the range of conduct and its relevance to the length of what's a reasonable period was recognized in the case of Sino, and I quoted from it in the slide. This is not to say that you can never explain non-cooperation. So for example, one can think of a case where you have a client who, for example, was found to have been a victim of torture in their country of origin, but the tribunal concluded that because of the current condition in their country, they would no longer be at risk. It is more reasonable, perhaps easier to explain why that person wouldn't want to go to their embassy or high commission and provide fingerprints. So as we said at the outset, all of these factors are always case specific. And of course, the overarching principle is that even in cases where a person is effectively doing everything to prevent their removal, detention cannot continue for a period which is unreasonable, and certainly cannot continue indefinitely. And it is also relevant, as was recognized in the case of NAB, what the Secretary of State has been doing. So she cannot, so to speak, sit back and not have a plan for what to do to affect the person's deportation, simply saying that this person will never leave. That would be unlawful and also links into the fourth Hardial Singh principle. I wanted to touch upon briefly on two other issues. One is the relevance of prosecutions under Section 35 of the 2004 Act, and that provision effectively creates a criminal sanction for failing to cooperate with the Secretary of State's efforts to remove the individual. So the Secretary of State can take specified action if she thinks that the person will, or that the action will or may result in an emergency travel document being granted. So one example is obtaining of fingerprints or providing information. And then there is a criminal sanction if the individual fails to comply with a request made under Section 35. And the punishment for non-compliance is imprisonment for a term not exceeding 2 years, a fine, or both. It is clear that it is not lawful to detain a person for the purpose of a Section 35 prosecution alone, and that is also obvious from the first Hardial Singh principle. But there is some recent authority which suggests that the pursuit or the threat of such a prosecution may impact on the likelihood of removal or be of some perhaps indirect relevance. And the case we have included for you is JM Zimbabwe, where the court said that there may be cases where the threat of a prosecution might secure a practical result, and the detainee may have said something to immigration officers which indicates a potential weakening in resolve. But the court emphasized that these cases will be in the minority. But in those cases, whether or not the Secretary of State is knowing that a Section 35 action might secure a practical result, whether or not she is pursuing that, is likely to be relevant to the consideration of the diligence with which she's trying to remove the barriers to removal. And finally, I want to briefly touch upon grace periods. So grace period is a phrase used when it becomes, when detention becomes unlawful or detention breaches the Hardial Singh principles. And the question is then whether the Secretary of State has to release immediately. And the courts have answered this question in the negative, saying that there is thereafter a period of grace to allow the Secretary of State to respond to the change in circumstances and take steps to effect release. So, for example, she may need to provide accommodation. She may need to liaise with other agencies like the police or probation in terms of approving a release address. And there is no fixed limit as to how long might be allowed, but the period, again, should be reasonable, which seems to be the key word in this area of law. There's a wide range of examples, as we've set out, from a couple of days to 24 days, sometimes weeks. A useful case, if you don't know it already, which I would invite you to read, is AC Algeria, which deals in detail with grace periods. And I have also included a number of recent decisions which are fact specific but useful by way of comparison as to what the period of grace might be. And some of those decisions have been made in the context of the COVID pandemic. And can be useful as a response to the Secretary of State argument, which still continues in 2022, that she has been so affected by the pandemic that her resources, especially in terms of finding accommodation, are very limited. So this is all I wanted to say, and I'm a bit worried that no one is going to introduce Graham, and he might not introduce himself. But I should probably say that in this area of law, Graham needs no introduction. He is, with no disrespect to him, Mr. Unlawful Detention, and one of the most highly respected practitioners in this area. And I can't see a better person to take you through the practice section of our presentation, which is basically what to do to best prepare your unlawful detention case based on Hardial Singh principles. So over to you, Graham.
Thank you so much, Agata, for your kind words. Yeah, so I'm going to sort of focus in on the issues around reasonableness, where Agata has looked in detail at the legal position, and give some consideration to how one goes about considering a case, building the evidence base for a case, and getting a case off the ground. Next slide, please. Sorry, can I have the next slide if anyone's able to do that? Thank you so much. And before I do that, I just wanted to pick up on one point Agata made about the interaction between the Hardial Singh principles and policy. Agata focused on the adults at risk policy. It's worth bearing in mind in this context as well, the broader Home Office detention policy that's now in what's called the Detention General Instructions, used to be Chapter 55 of the Enforcement Instructions and Guidance, because part of the purpose of the Home Office's detention policy is to guide its caseworkers to make decisions that are in compliance with the Hardial Singh principles. So the policy gives you a sense of whether the Secretary of State sees the boundaries of the Hardial Singh principles as lying. Obviously, it's a detailed and quite lengthy policy, but there are a few general principles that have survived in the current version that are worth bearing in mind. That detention must be used sparingly, it must be used for the shortest period necessary, and that use of the importation of the concept of necessity is quite interesting because you don't get that directly from Hardial Singh. There's a presumption in favor of release or more recently an immigration bail, and the Secretary of State is required to give proper consideration to alternatives to detention when considering whether or not to detain. So a failure to do those things will be a public law error because it will be a failure to take into account relevant policy, but it also guides the way you might want to think about the application of the Hardial Singh principles. So I'm going to go on to look at some evidential issues. I should stress at the outset that this is not intended to be exhaustive. As Agata said, all of these cases turn on their own facts. Cases often throw up very unusual circumstances that you can't predict in a sort of general session like this. But I hope that I've covered a fair amount of ground that at least will give some pointers as to where you might want to be looking when you're thinking about these kind of cases. Could I have the next slide, please? So obviously the first potential source of evidence is your client, and in some cases it may be your only potential source of evidence, at least at the beginning of the process. So you need to consider what documents do they hold that give some clues as to the circumstances of their detention. Do they have bail summaries? Do they have some IS 151 monthly progress reports? Do they have some immigration decision letters, determinations, removal directions, counsel removal directions, judicial decisions, and so forth? They may have material that at least gives you something of a picture of what's going on. There are some matters, as Agata said, that are personal to your client that you're not going to get from the documents, particularly around conditions of detention and the impact of detention. So you'll need instructions from your client on those, equally in relation to the impact on their family. There will be cases, obviously not all cases, but there will be cases where the impact on people beyond the detainee is a relevant factor in Hardial Singh reasonableness, and you'll want to get statements from family members who are impacted. There may be, for example, a former employer who can give evidence that may be helpful to making your case an absconding risk, that sort of thing. Could I have the next slide, please? If you have it, and you won't always have it at the outset, the Home Office, your client's Home Office file, which you'll get from the Home Office Data Protection Unit by way of a subject access request, should contain a huge amount of fairly vital information. The process seems to be at the moment, as I understand it, that a subject access request is initially met with a copy of the electronic documents held by the Home Office, and you have to follow that up with a supplementary request for the paper file, which at the moment will then be provided during COVID. They were only provided during the sort of height of the lockdown period. They were only providing the electronic documents. But between those two sets of documents, you should get a fairly comprehensive picture of what's been happening. Within the electronic file, you'll have the GCID notes, which are the electronic file minutes. That gives you a sort of day-by-day record of what's been going on, lets you trace through the chronology. Tip in relation to that is you need to read them all. What you see quite often is you'll have multiple sets of GCID notes, one of which might be 100 pages. Then you might have another 20 sets, which run from sort of 2 or 3 pages through to maybe 15 or 20 pages. And they seem to be duplicative. And the temptation can be to only look at the lengthy one. But you will find that often there is material in the shorter notes that isn't replicated in the longer one. And you really need to trawl through all that repetitious material to make sure you've seen everything. You'll see in the electronic file notes a document called the CID calendar events. That's a record of individual events. It can be helpful in that it contains a record of individual reporting events. So if you're trying to demonstrate that your client doesn't pose a risk of absconding, that can be helpful evidence to prove that they showed up to report when they were required to, or equally it can demonstrate the contrary. Detainee detention history and ASU call notes have records of things that have happened in detention, sort of events in the IRC. You may find copies of other documents such as the minutes of decision to detain, detention reviews, decision letters. There's a sort of elusive document where there's a sort of low-level decision taken that somebody should probably be released, but that they can't actually be released until a more senior official has signed off on it. A referral called a release referral is made. It's very rare to actually find those referrals on the Home Office file. Occasionally you find them in the electronic file minutes. If they seem to be critical, you may need to seek separate disclosure of those. And could I have the next slide, please? Within the paper file, you may find duplicates of documents you've seen in the electronic file. You might find manuscript file minutes, particularly in older files, correspondence, including representation, decision letters, orders, and decisions of courts and tribunals and so forth. The minute of decision to detain is a sort of document that takes the same form as a detention review, but is prepared before detention begins. And that records the Secretary of State's analysis of the case and the reasons for detention at the outset. It should contain a brief chronology of the case. It should contain an assessment of absconding and offending risk. It should contain an assessment of how long it's likely to take for the person to be removed. It should deal with issues like family connections, vulnerability, whether or not the person is an adult at risk, and other factors the Secretary of State considers relevant to the decision to detain. It's prepared by the case owner, who's a sort of relatively junior official with day-to-day conduct of the case, and then signed off month by month. Sorry, so the initial detention, the minute is signed off by a more senior officer, and then each month detention is reviewed in a similar format with a sort of review signed off by a more senior official. You may also find medical records and reports in the Home Office file. Can I have the next slide, please? Likewise, you might find Rule 35 reports, which can be useful evidence about the potential impact of detention on an individual. You might find bail applications, bail summaries, bail refusals. Bail refusals can be pretty critical. If they contain strongly adverse comments, the Home Office are likely to rely on those in the context of an immigration detention challenge. So you need to be ready to meet any points that have been raised against your client by an immigration judge in refusing bail. You may also find Oasis reports or NOMS 1 documents. Oasis reports are formal probation risk assessment documents relating to risk of offending and risk of harm. The NOMS 1 is a sort of summary of the Oasis report that's prepared by the probation service for the Home Office and basically summarizes the analysis in the Oasis report. You may also find sentencing comments, pre-sentence reports and so forth, all of which can be relevant when you're trying to make a case in relation to offending risk. Have the next slide, please. There may be cases where it's worth making subject access requests to other public bodies. If it's a case where the client's background of offending or background in custody is relevant, you may want to get a copy of the MOJ file. In trafficking cases, you may want to get a copy of the Salvation Army records. Have the next slide, please. In cases involving family issues where there's a history of involvement with social services, you may want to obtain relevant social services file. And just a red flag there, if you are looking at a case in which issues around family proceedings or care proceedings are potentially relevant and you're going to want to refer to that in the context of your detention challenge, be very mindful of the fact that documents and information emanating from family proceedings that have taken place in private cannot be disclosed in any other context without the leave of the family court. If you're going to need to rely on those documents, you need to make an application to the family court for permission to do so before you take any steps in relation to that, or you'll find yourself in contempt of court. There's a very helpful article in relation to that on free movement by Rachel Francis of One Pump Court that I'd urge you to read if you're ever having to deal with those issues. Could I have the next slide, please? Medical records, if there are potential medical issues in your case, you'll want to get the medical records. Expert reports, if it appears to be the case that detention is impacting on your client's mental health, you'll want to investigate that with appropriate expert evidence, whether from a psychiatrist or a psychologist, or potentially an appropriately qualified GP. In relation to offending risk, you may want to instruct a forensic psychologist or psychiatrist to produce a report on that. That can be particularly helpful if you're looking at a case involving someone who's been convicted of quite serious offending, but quite a long time ago, where all the risk assessments are quite negative, but they're also quite old, and there's sort of prima facie evidence of rehabilitation, but nothing that really is going to get sufficient traction with the court to outweigh those old unhelpful assessments. Getting a new up-to-date assessment from a forensic psychiatrist or psychologist on offending risk may help tip the balance in your client's favor, assuming they take a favorable view. In the adults, the most recent Home Office Adults at Risk guidance, which is the sort of adjunct to the statutory guidance, it contains detailed instructions on what they should and shouldn't accept from medical experts and all sorts of criteria that should now be fulfilled. So bear that in mind when instructing psychiatrists, because you'll want the report to take a form that the Home Office are likely to give credence to. Could I have the next slide, please? Other expert evidence, perhaps from country experts, may be of use if you're dealing with issues around removability. Could I have the next slide, please? Equally, there may be reported cases that contain an analysis of a particular issue of fact that arises in your case. So, for example, in the case of SW that Agata was involved in, it contains some very helpful comments about removability to Eritrea that one can just pick up and rely on in Eritrean cases that one's trying to plead going forward. Equally, tribunal country guidance cases may contain relevant evidence about removability or documentation in the country of origin that could feed in to issues around removability or documentation. Next slide, please. Perhaps goes without saying, but previous representatives' files, immigration solicitors, criminal solicitors, family solicitors are also a useful source of information, of documents if it's not forthcoming from other sources. Next slide, please. At the outset, you're not necessarily going to have very much, particularly if you've picked up the client in detention, you haven't been acting for them previously. You get as much as you can from the client. As I said, bail summaries or an immigration factual summary, if that's been produced, may give you a helpful overview of the previous chronology. You need to make a judgment about how long you need to spend investigating the case before you can get it off the ground. If you are going to begin proceedings before you have the full set of Home Office papers and so forth, the utmost care is needed not to say anything misleading or inadvertently misleading when you don't have a complete picture of where things are from the documentation. Be clear about the information you have, be clear about what you don't yet have, be clear about any gaps, be clear about where you're relying solely on your client's instructions. Give the ideally you'll want to give the Home Office a chance to respond and fill in the gaps. Next slide, please. I'm not going to deal with this in any detail, but suffice to say, you can ask for disclosure in pre-action correspondence. If you don't get the disclosure you need, there are mechanisms in the course of litigation, whether under CPR Part 18 or under the specific disclosure procedure, to apply to the court to require the Secretary of State either to provide you with information under Part 18 or to provide you with specific documents. And that can be used to great effect if you think that you've not been provided with a complete picture. Next slide, please. In terms of investigating barriers to removal, the Home Office maintain the country returns guide, which is a sort of Excel spreadsheet that has very basic information about the removability to all the different countries that the Home Office remove people to. It can be useful, but it's pretty vague. Returns logistics within the Home Office maintain more detailed guidance notes in relation to some countries, they're not in the public domain, but they are disclosable, and they can be obtained in judicial review proceedings. If the Home Office won't hand them over, you can seek an order. Next slide, please. In terms of length of detention, it's usually pretty clear how long that is, but it isn't always. If your client's been in and out of remand, if they've been recalled following a period on license or whatever, sometimes the Home Office thinks they're in immigration detention when actually they're not. They're detained for some other reason. In terms of the prospective length of detention, Agata's touched on this already. You need to be looking at what are the barriers to removal and how long they'll take to resolve. Next slide, please. Legal barriers such as asylum or human rights claims, further representations, ongoing litigation and so forth. You need to consider whether or not the claim is obviously unmeritorious. If it is unmeritorious, it's unlikely to attract any weight. Assuming it has some merit, you need to give careful thought to what's the potential timescale to resolution. If it's a tribunal appeal, how long a tribunal case is taking at the moment. If it's an upper tribunal case that's on its way to the Court of Appeal, can you give a realistic estimate for how long that's going to take? Is the next decision going to resolve matters, or are you going to have to go back to the beginning and start all over again? Think very carefully about those factors to build your arguments around the delay that those matters will cause. Next slide, please. There are then practical barriers, as Agata has then touched on, in relation to the ETD process. Sometimes that's to do with the country. A particular country may have fallen out with the UK or may not have a functioning government, and there may not be an ETD process at all. Certain countries allow returns, but only where individuals agree to voluntary return. So someone's refusal to agree effectively precludes removal. Some countries are cooperative, but are just very slow. Sometimes there's physically not a viable route of return to the safe place that the person needs to be returned to. Sometimes the client is obstructing matters by refusing to fill in forms, answer questions, attend interviews, and so forth. Those are all going to have a bearing one way or the other on reasonableness. Next slide, please. In terms of diligence, speed, and effectiveness, you need to look at the internal records, take a view on what the Home Office has been doing, approach it with a critical eye. Sometimes I get the impression that things are done just to make it appear as if things are being done. And actually, the fifth ETD interview doesn't yield any different results to the first ETD interview. And in those circumstances, query whether that's really progressive and query whether doing the same thing over and over again counts as acting diligently. Next slide, please. Conditions of detention, again, I'll leave you to read that, but I mean, broadly, you need your client's instructions on the way in which conditions of detention are impacting on their experience of detention. List some factors there that are going to be relevant. Next slide, please. Likewise, the impact of detention on the detainee and their family. You'll need instructions, potentially medical evidence or social work evidence in relation to that. Next slide, please. And then in relation to absconding risk, you need to do a careful audit of what are the factors weighing for and against. Risk factors will include things like past absconding, past serious criminality, convictions for breaching court orders, lack of ties in the UK, a bad immigration history in the UK, past use of aliases, past adverse judicial findings in the past, deception in the removals process or obstruction, the fact that somebody's at the end of the road, or the fact that removal appears to be very imminent. Next slide, please. Protective factors in relation to absconding risk include basically the opposite of the previous slide. So past compliance, evidence of past compliance, particularly significant where it's been in the face of a risk of removal. Ties in the community, family ties, other ties, absence of past criminality, evidence of cooperation. The Home Office policy recognises that outstanding representations or appeals are likely to be an incentive to cooperation, medical issues that require a person to remain in contact, and the existence of settled accommodation. Just one. Next slide, please. Again, I'm not going to go through this slide in detail, but very broadly, in terms of offending risk, you are going to want to be looking at the Oasis reports, NOMS 1 reports, past findings, pre-sentence reports, and if necessary, expert evidence to try and counter any previous adverse assessments. Next slide, please. And then just a few tactical points to close. The first is a question that often comes up is whether, if you're considering judicial review, it's appropriate still to apply for bail. In my view, it is. Not everybody always agrees with that. There is some risk in applying for bail, in that you could get very negative decisions from an immigration judge refusing bail that could then prejudice your judicial review claim. On balance, my view is that that is generally a risk that's worth running, because the bail application can bring matters to a close so much more quickly. Interim relief, consider carefully whether it's worth going for. It often is, but it isn't always worth going for. If you are going to seek urgent interim relief, have careful regard to the recent authorities from the admin court about claimant's duty of candour and the abuse of the urgent application procedure. They're taking a particularly stringent line in relation to claimants' representatives at the moment, and you need to be sure that you have your ducks in a row procedurally before you ask the court to consider anything very urgently. Next slide, please. And the final point to note is just that these are public law challenges, so you can't issue a claim bringing in evidence that has never been before the Secretary of State. If in the course of preparing your case you come across evidence, or you obtained through, for example, expert reports, evidence that hasn't been seen by the Secretary of State, the sensible thing to do is put it before the Secretary of State, ask them to review detention before you take matters any further. Sometimes matters are moving so quickly it's not possible to do that, but in the vast majority of cases it should be possible to do that. Okay, I've overrun my allotted time, for which I apologise, but I'm very happy, we're all very happy to consider questions if there are any. It doesn't look like there are at the moment. But yeah, thank you very much.
Yes, we'll give it another minute to see if anyone has questions, but as Graham said, you will be sent the slides afterwards, and if there are any questions arising out of it, feel free to message us. I don't think we have anything, so I guess we'll conclude.
Yeah, Ray has, if you'll see Ray's comment, she said that she'll put in a poll about, there you go. If you would kindly fill that in, that would be really great. It helps us improve or disprove if we're too good. Sorry. Great.
Great. Well, it looks like there are still no questions, so I think let's perhaps wrap it up. But thank you everybody who's attended today. We really appreciate it. Thank you to my co-presenters for really interesting and informative presentations, and we look forward to seeing you at the next event. Thank you so much.